Ready, start. Section 10 requires the state government to place before the advisory board the detention order and grounds on which such order may have been made, along with the representation made by the detainee, as well as the report of the officers made under section 3 within bracket 3 of the act within 3 weeks from the date of detention. Under Section 11, Advisory Board is required to consider the materials placed before it and, after hearing the detainee, to submit its report to the state government within 7 weeks from the date of detention of the person concerned. In a case where the advisory board forms opinion that there was no sufficient cause for the detention, the state government shall revoke the detention order, but if in its opinion sufficient cause was made out, the state government may confirm the detention order and continue the detention of the person concerned for such period not exceeding the maximum period as specified in Section 13 of the Act. Section 13 provides the maximum period for which a person can be detained in pursuance of any detention order made and confirmed under the Act. According to this provision, the maximum period of detention shall be 12 months from the date of detention. The state government has, however, power to revoke detention order at any time it may think proper. Provisions of the aforesaid sections are inbuilt safeguards against the delays that may be caused in considering the representation. If the time frame as prescribed in the aforesaid provisions is not adhered to, the detention order is liable to be struck down and the detainee is entitled to freedom. Once the order of detention is confirmed by the state government, maximum period for which a detainee shall be detained cannot exceed 12 months from the date of detention. The Act nowhere requires the detaining authority to specify the period for which the detainee is required to be detained. The expression single inverted comma the state government are satisfied that it is necessary so to do, they may, by order in writing, direct that during such period as may be specified in the order occurring in subsection within bracket 2 of section 3 relates to the period for which the order of delegation issued by the state government is to remain in force and it has no relevance to the period of detention. The legislature has taken care to entrust the power of detention to the state government, as the detention without trial is a serious encroachment on the fundamental right of a citizen. It has taken further care to avoid a blanket delegation of power to subordinate authorities for an indefinite period by providing that the delegation in the initial instance will not exceed a period of 3 months. But if the state government, on consideration of the situation, finds it necessary, it may again delegate the power of detention to the aforesaid authorities from time to time, but at no time the delegation shall be for a period of more than 3 months.